Welcome back, everyone, to the latest edition of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. My name is Rich Lenkov. I'm the host of the SERMAPod. I'm also the founder and CEO of SERMA. We're very glad to present another great podcast, really interesting, timely. All of our podcasts, we endeavor to deal with subjects that are right out of the headlines, and this one certainly qualifies. Bret Favre has filed a lawsuit against three defendants, two of whom are very prominent ex-athletes who are now sports broadcasters. One is named Shannon Sharpe, the other is named Pat McAfee, to discuss this issue and explain generally the standard of proof and defenses with regard to defamation claims, particularly among celebrities and athletes, is David Hollander. David is an attorney with Stafford, Rosenbaum, out of Wisconsin. He's also licensed in Illinois. David, welcome to the SERMAPod.
Thanks, Rich. Happy to be here.
I know you wrote an excellent article on this that is in the May 2023, the upcoming edition of the Wisconsin Lawyer magazine. Great publication. You're giving our viewers and our listeners a little sneak preview here. So just as some backdrop, Bret Favre, as I mentioned, has filed a defamation lawsuit alleging that as a result of some, what he says are untrue statements by three entities, two of whom are Shannon Sharpe, who is an ex-professional athlete, tight end for the Broncos and the Ravens, now a very prominent host of a show that has a lot of listeners, and also Pat McAfee, who is most notably known as an ex-special teams player for the New Orleans Saints. He is an analyst for College Game Day on ESPN. He also hosts a very popular podcast. Ironically, most people know him from his weekly interviews with Favre's successor on the Packers, Aaron Rodgers. He's alleging that these two individuals have broadcast and have made statements about Bret Favre that are not true and therefore have defamed him and therefore have resulted in economic loss to him and to his reputation. In particular, this, David, derives from these allegations that have been made that have never resulted, we should note, in a criminal charge and certainly not a criminal prosecution of Bret Favre. But this surrounds allegations made of welfare fraud, basically. In Mississippi, that Bret Favre received money to the tune of, I think, $1.1 million that was for a speaking fee that never actually took place, and also towards a volleyball building for his daughter's university. And the allegation goes that that money should have been used to help needy people in Mississippi, that money was improperly taken from the welfare fund and given to these two resources. Now, Bret Favre, of course, has denied that this has taken place. He's repaid this money, which Mississippi has acknowledged. And again, very importantly, he hasn't been charged criminally. That all being said, that has resulted in these two individuals alleging that he's been engaged in thievery. They used the word thief. Shannon Sharpe said that he was a mofo. And the words that were used, again, according to Bret Favre, resulted in loss of economic opportunities to him and loss of his reputation. So that's kind of the backdrop. David, talk to us about understanding the burden of proof is always on a plaintiff in this case. What does plaintiff Bret Favre have to prove in his defamation case against these two individuals?
Yeah, Rich, well, at a high level, you got four elements of a defamation claim. It's got to be, one, false and defamatory. Two, a non-privileged publication to a third party. Three, it's some degree of fault, and we'll get into that in some depth. And then four is the harm, some sort of harm that results from it. So that's what Favre's going to have to prove. That's what any defamation plaintiff generally has to prove. Those elements vary a little bit from state to state, but the First Amendment issues are looming large in the background. And so there's certainly consistent threads all across the country.
So let's break those down briefly, if we can, for our viewers and our listeners, because it's really interesting. And like in all causes of action, you really do have to prove each of those elements. Otherwise, your cause of action fails, right? So let's go through those briefly, if we can, explain what they mean.
Yeah, so we can start with the false statement. Really two elephants looming large in that room. The first is something that probably most people know about defamation, or most of your listeners will know, and that's that truth is an absolute defense. And so if you're someone in Bret Favre's shoes and you're making this decision about whether you go and you file this suit, you got to know what you're opening yourself up to. You are right that Favre has not been criminally charged, but his lawyer confirmed that he's been interviewed by the FBI. Other folks who had more direct involvement have been criminally charged here. And so if you're Favre, one of the calculations you've got to be making is this worth it? Do you really want to manufacture an opportunity to go under oath when you're somebody who's been interviewed by the FBI?
Because David, to your point, of course, what you say in the civil action can be used against you in a criminal action, unless, of course, you invoke the Fifth Amendment.
Right, which is going to put you in a real bizarre place if you're saying someone falsely accused you of a crime and you're going to invoke the possibility of jail time as a privilege against giving testimony in a civil suit. So that's a real difficult choice that a plaintiff has to make in these circumstances. Is you could lose, and you could have a judge come down and say everything they said you did. The other big issue that's looming under this kind of false element is whether it's actually a statement of fact. As you said, the sportscasters were saying things like he stole money from people that really needed it. He's stealing from the poor people in Mississippi right now. He took money right out of their pockets, things like that. And so there's a real question here as to whether those are statements of fact. It's a little bit like in any sort of fraud case or false advertising case where you have puffery issues. It's one thing to say we have the best used cars in town. It's another to say, this car has 10,000 miles on it when you cracked open the odometer and rolled it back. Similar issue on this statement of fact, where to be sure, saying someone is stealing, could mean they violated a criminal statute and they should be going to jail, or it could mean some other things. And I think that's the threshold issue that Favre is going to have to get around under this falsity element.
All right, what's the next element?
So the next element is a non-privileged publication to a third party. There's some privileges that apply. There are privileges that apply if you're testifying in a court proceeding, if you are a legislator in the course of debate, if you're a journalist in print. Many states have, maybe all states have certain privileges that apply in that context. So there's privilege questions, but really it's publication to a third party. And here there's no doubt that all three of them published these statements to a third party.
Not just a third party, but I think the listenership of one of them is like 70,000. So there's no question, as you said, that this element of the cause of action is easily provable. What's next? Yeah,
the next is the degree of fault. In every case there has to be at least some degree of fault. Most commonly, it's a negligence standard. But then we've got the New York Times versus Sullivan opinion that people may be familiar with, which, that opinion and subsequent opinions have established a standard when you're a public figure and you're suing for defamation. There's a heightened degree of fault that you have to prove. It's not just negligence. You have to prove that the publisher acted with actual malice. Actual malice is the standard. And, despite what it sounds like, it doesn't mean you had hatred or you reviled Bret Favre. But actual malice means a whole lot more than negligence. It means that you have to have been acting either intentionally or recklessly, and that you had to have, in fact, actually have serious doubts about the truth of what you're saying. So it's a high burden to meet.
Yeah, maybe you could explain a little bit what the logic is behind that standard, the elevated standard when you're dealing with celebrities. And it's interesting, another high-profile defamation case going on right now is the Dominion lawsuit, right? Last week it was revealed that in the lawsuit brought by Dominion, which is a maker of ballot boxes in the last election, they're alleging that they were defamed by Fox News. Fox News said that Dominion was involved in, stealing the election and that they were involved in voter fraud. Well, it turns out that through discovery, we learned that some people at Fox News, including Rupert Murdoch, the head of Fox News, and a lot of their most prominent on-air talent like Laura Ingraham and many others, Jesse Waters, were admitting behind the scenes to each other through a series of text and phone calls that these theories, these conspiracy theories, were nuts. Yet they went on the air, and despite their apparent knowledge of the lack of veracity of those claims, were continuing to tell millions of viewers that they might be accurate. So in that case, it seems like there is a smoking gun, which is pretty much required to prove actual malice. But it is hard to generally prove that absent that kind of communication. And why is it important, or why is that standard there when you're dealing with high-level defendants like celebrities, or plaintiffs like celebrities? I should say.
Yeah, funny that you invoke Dominion. When I started practicing law, I thought searching the emails would reveal all sorts of smoking guns, right? And one of the first lawyers I worked with was like, the emails had their moment in like the early 2000s when people didn't realize that everything they wrote was going to come out in discovery. That's mostly past. But here we have it with Fox. And I think
who didn't read that memo was Tucker Carlson, apparently.
Apparently not. But I think the reason that you're in a position like that is because of these cases are so hard to prove. And I suspect a lot of these folks at Fox had won a lot of defamation cases over their careers really quickly because we have this really protective standard, and we have it for good reason. So we want people who are, in places of power, in places of influence. We want, under our First Amendment standard, folks to be able to investigate, discuss them, and discuss those implications without, fear of retaliation, without fear that you have to research to such a fine tune every little thing you say. We can. There are certainly questions about whether that's good or bad. The United States is a little bit of an outlier in that regard. It's harder to prove a defamation case here than in some other countries with similar legal traditions. But here we value the First Amendment, and if you're somebody who is really active in these public spaces, it's just something you have to accept, that people are going to say things about you. They're going to say things that are negative, and sometimes they're going to say things that aren't true.
All right, Brett. So I
would also add that, one real quick point on that is, if you're a public figure like Bret Favre, you also have the resources and the ability to kind of counteract some of those negative statements. I mean, any show in this country would host Bret Favre to come on and tell his side of the story. He could do that if he wanted to, and that's not something that necessarily you or I could do if someone defamed us.
Yeah, it's a great point. The last element is damages that Bret Favre has to prove. By the way, one of the biggest surprises from reading this complaint was Bret Favre's middle name. Who knew or would even guess that his middle name was Lorenz?
I did not know it. But though I live in Wisconsin, I'm from Chicago, so maybe I wouldn't know it. But yeah.
What damages is he seeking, and what does he have to prove to sustain that element of proof?
Yeah, so before you quite reach damages, there's a more fundamental question that's kind of balled up with it, which is harm. And so generally, if you're suing somebody for defamation, even to survive a motion to dismiss, you have to show some sort of demonstrable harm that came to that person. And so if you falsely said, David Hollander, he's never given a dime to charity, maybe that actually harms me, maybe it doesn't. If I've built my career around being this charitable, giving lawyer, and I start losing clients because they think I'm kind of a fraud, then that's the sort of harm I would need to allege in a complaint. Or if I'm part of a charitable organization and or a religious organization that's a fundamental tenant, they might start to see me differently. So you need to generally just to survive a motion to dismiss, have some sort of tangible harm that you can point to. There are an exception in most states where you don't have to point to any specific harm, and that's defamation per se. And so those are the categories where it's just assumed that these are so revile of allegations that the law assumes that you will have been harmed. If somebody says that you committed a crime falsely, if they say that you were unfaithful in your marriage, if they say you were bad at your job, certain categories like that, where the law presumes that you've been harmed. But then the next question would become damages.
Yeah, so this certainly seems to qualify as defamation per se, given the egregious nature of the crimes that he's being committed of. As Shannon Sharpe said, stealing money from poor people, he said, it doesn't get much worse than stealing from the lowest of the low. So that certainly qualifies as defamation per se, if proven. What would he be rewarded or awarded if he's to prevail in this lawsuit?
Yeah, I mean, he's going to be trying to get compensatory damages. What exactly kind of remains to be seen. We do know that, for example, it's been widely reported that Coppertone, who he was a sponsor for, has kind of started to purge him from their website and from other materials where he was prominently featured. So I suspect he'll have kind of a litany of kind of lost business opportunities that he'll be at least trying to say are damages in each of these cases. But I do think he'll have a little bit of a causation problem on his damages, because if everybody caused you these damages, then did anybody cause you these damages? You've got 3 different people who he's sued, and he says he can't say each one of them caused him to lose a Coppertone deal, for example. Separate and aside from the statements out there that he says are false and defamatory, there's a lot of truthful reporting that he doesn't even contend to be false about his involvement in Mississippi. And if I'm defending the case, I'm really exploring how, even just the true reporting alone might have hurt his reputation and caused those losses. And so I think it's going to be a really messy damages case, I think.
All right, so you mentioned defending it. Let's turn to that part. So Pat McAfee was served, I think he said, on Monday or Friday, the last few days, and has been very public in saying that he's not going to hire a lawyer, right? He's saying, let's go, let's let it roll, because he seems that confident in his case. Who knows if that'll be the case, right? It's all well and good to say that you're going to go pro se until you're actually served. So we'll see. It's also notable that Bret Favre's lawyer has said that Pat McAfee could go bankrupt and will learn his lesson from this defamation suit. So both sides seem to be entrenched in their positions. But that being said, you mentioned truth as an absolute defense. We understand that. What other defenses do you think will be raised? A couple defenses that are a little amorphous in Mississippi seem to be justice, right? That if you're saying these allegedly defamatory statements in pursuit of justice or in the public interest, then those are defenses. What do those mean? I mean, if I'm the defense counsel, I'm certainly throwing those up there and saying, well, of course we're saying those. My client said those in the pursuit of justice because he was allegedly stealing from poor people, and that's also in the public interest. What does that even mean? Will that hold water? What do you think?
Yeah, I don't know. I'm not too familiar with that defense, but it does strike me as the sort of defense that would render any sort of false allegations of criminality, totally illusory, right? In any case where you said somebody committed a crime, and they didn't, and you could just say justice. Right. So I don't know. I'm not too familiar. That's just me kind of talking off the cuff. But it seems to me like that would be. I have a hard time seeing that be something that would work, where we have these, criminality as a recognized defamation per se category.
All right, so then we'll jump into the mindset of Shannon Sharpe and Pat McAfee. Talk to us about what defenses they would raise in explaining what they meant when they said what they said. Although it seems like Pat McAfee again is not going to shy away from the position of, yeah, I said it and I meant it, so be it.
Yeah. Yeah, I mean, I think the first thing really comes back to that question of, is it a statement of fact?
Right.
And, if you look at stealing in the dictionary, there are certainly definitions. And I should say the dictionary does not control in this context, but it's kind of a helpful guide. There are certainly definitions of stealing, which mean just, the criminal theft statute, taking something that doesn't belong to you with intention to never give it back. There are other definitions that are more like trick, surmise. We stealing third base, right? Nobody means that to say that you picked up the base and walked away with it. So there's a little ambiguity there, and when you're dealing, there's a lot of litigation. There has been a lot of litigation over the years around the word theft, stealing, in particular. And what the courts have said is that the context really matters. It really matters a lot. And so it's one thing for me to say, Rich was my trusted confidant. He's the only person who I knew where I was keeping stacks of cash in my, apartment. It went missing. And then the next day, Rich was driving this new car and retired. He's a thief. Clear what I'm saying there. But in other contexts, sometimes in the course of political debates, candidates say the other person's corrupt or they're a thief. And those are closer calls. So I think one of the things that they'll say is, we didn't mean to say that he was committing a criminal act, but just that he was a dishonest guy. And so I think that'll be one of the defenses. The other one I think will be the actual malice issue.
David, last question here on SERMAPod. How do you think this ends, right? You talked about the aversion of public figures to bring defamatory cases because it opens up a can of worms and actual discovery into their personal lives. This is particularly significant with Bret Favre, who, again, there is presumably an ongoing criminal investigation. We don't know how long that takes, and he could give testimony that could endanger his liberty criminally. So given that context, do you think that this case gets resolved? Do you think it goes to trial? What are your thoughts?
Yeah, I mean, I think his case against, remember, it's a case against one auditor, the auditor from Mississippi who released this report, and then also went on, a number of news publications to talk about it. And then it's also a case against the two sportscasters. I think that the case against the sportscasters is going to be a really big uphill battle because, again, he's going to have to show that actual malice standard. And if I'm them, I'm attaching the complaint against the auditor as Exhibit A to my motion to dismiss and saying, look, this guy whose job it was to investigate this said all of these things. He said that Favre was a thief. He said he was taking the money. And we just relied on that. And that might be negligent, might not be, but certainly can't arise to the level of actual malice. And then as to the auditor, I think there's probably some kind of tort immunity issues that they'll weave through. And but still, he's going to have to show actual malice. And as to all three of these defendants, all he's really pointed to as actual malice is they're trying to be famous off of my fame. Use talking about me to build their own profiles, their own brands. I just don't know if that's going to cut it. We've had allegations of yellow journalism for many decades in this country, and that doesn't mean that they actually had real doubts about the truth. So I think it's going to be an uphill battle. And, at the same time, Favre, if he survives a motion to dismiss, he's going to get deposed. And I think that's a sort of risk that I'm sure he thought carefully about before filing these, but one that I would have real reservations about doing.
David Hollander from Stafford Rosenbaum. The excellent article that he and his colleagues wrote on this subject can be found in the upcoming May 2023 edition of Wisconsin Lawyer Magazine. Before we let you go, you are in Wisconsin. You grew up in Chicago. I got to ask the obvious question when we're talking about the hated. I'm happy to say that in a non-defamatory way because he's a member of the Packers. But Bret Favre, Packers or Bears?
Bears. I was more of a college fan. Wasn't that big of a Bears fan, but then I moved to Wisconsin, and people were giving me a hard time anyways. So if they were going to give me a hard time, I figured I might as well start cheering for the Bears, and so here I am.
It's the right answer. Big things coming up in next season for the Bears.
Hope so.
Number one pick for now. We think they're going to trade it, but we're hoping for big things, looking for big things out of the Bears. And again, Dave Hollander, thank you so much for joining us on the SERMAPod.
My pleasure.
Ideas, strategies, and opinions represented on this podcast are those of the speakers and do not represent the ideas, strategies, and opinions of their employers.